Hi, everybody. Thanks so much for joining. I am going to try to figure out how to make this music. Hi, everybody. Thanks so much for joining. Let's see. I am going. There we go. Sorry about that. Technology is not my strong suit, but thanks so much for everybody for joining us. I'm Tom Carpenter, and I'm really happy that so many people have joined us today on Facebook. And obviously, I think we all know why we're here. There was a lot of press about a lawsuit that's been filed recently, suing a travel agency for an incident that happened in Mexico. And when that lawsuit became public, a lot of people reached out to me asking for guidance about how to deal with situations like this, how to protect their business. Those of you who know me and have worked with me know that my kind of the thrust of my legal practice is that I want to help travel agencies and small travel businesses manage legal risk in their travel business. I've done lots of webinars on this topic. And in addition to my law practice, I actually own a small travel agency myself. Before I get started, I wanted to just take a moment to give a couple of shout outs to my family at Uniglobe. My business is hosted by Uniglobe, and I know that many agents who are here, advisors who are here, are also Uniglobe advisors. So I'm really happy that Uniglobe is here. Also wanted to give a shout out to a couple of people who run some Facebook groups who help push it out. Particularly Lori Gold from the Resorts of the Riviera Maya Facebook group, which I'm a member of that group, as well as a big fan of that group. Such incredible resources there. And also Helen Coachella, who runs a group for new agents and new advisors, where there's a lot of really good information there. So I know there are others out there who've reached out to me, but I particularly wanted to shout out to Uniglobe and those two Facebook groups. So I am going to just give you a little bit of I need to start by getting rid of some professional responsibility guidelines. So I'm going to just kind of burn through that as quickly as I can so that we can get to the substance of why we're here. I am obligated to let you know how you can find me if you want to reach out to me. This slide will be up again at the end of the program with some additional information if you want to set up an appointment with me. But just to get my professional responsibility disclosures out of the way, I am an attorney. This presentation should be viewed as attorney advertising according to the states where I'm licensed. This is for informational purposes only. I am not intending to provide specific legal advice to any of you, in any specific way. I'm seeing that I need to speak a little bit louder, so I will do that. Participation in this webinar does not create an attorney-client relationship. So by viewing this webinar, unless you have a representation agreement in place with me, I am not your attorney, and prior outcomes don't guarantee future results. So just because something happened one way might not be the case that will happen the next time. So, okay. A little bit about me. I have been practicing law for about more than 25 years at this point. For most of my career, I represented clients in the arts, entertainment, and media industries. I was the former general counsel of a couple of different labor organizations in the entertainment industry. I worked for AFTRA. I was chief labor counsel at Screen Actors Guild for a brief moment and worked on Broadway for Actors Equity. But I'm admitted to the state bars of New York and Illinois, but I'm also licensed to practice in several federal courts, including the United States Supreme Court. Questions come up from time to time. If I'm not in New York or Illinois, can you represent me? I have clients in transactional matters all across the country. I cannot go into court for you, but I also don't litigate. So, but in New York and Illinois, I could do that. I'm also licensed to practice before the United States Supreme Court. And in addition to my uh, law practice, I also own a small hosted travel agency, as I mentioned before. So, and apologies about the sound being muffled. I'm not sure why that is, but uh, um, I'm apologizing for that. Okay, let me just pause for a minute and see if I can find a headset to use. Maybe if that'll help. Okay, let's see if this works. Are people able to hear me? Are people able to hear me now? Is this any better? Okay, much better, thank you. Okay, I'm assuming this is okay. All right, so let's try this one more time here. So I want to just go through a couple of things. We went through my professional responsibility disclosures. Great. People can hear me better now. Apologies for that. So here's the premise um, of the whole presentation. Selling travel is a risky business. There is legal risk anytime that you sell travel. There are all sorts of things that can go sideways when your clients are traveling. Accidents, negligence on the part of suppliers, crime, terrorism, civil unrest. We're all dealing with flight cancellations right and left these days. Supplier defaults. We had some supplier defaults as a result of the pandemic, but if a supplier goes bankrupt, leaves you holding an empty bag, that can be a problem. And even lost, stolen, or damaged property. We're having all sorts of problems with lost luggage right now. And so all of these things that go sideways when your clients travel create the potential for legal risk for your travel business. So the good news is that those risks can be managed. So you can protect your business from being sued in the first place. And if you are sued, you can also minimize your exposure once that lawsuit is filed, depending on how you handle it. So we're going to talk about all of that right now. If you have questions as we're going through, put them in the chat. I'm happy to look at them in the comments, either on Facebook or YouTube. They're both coming through to me, and I'll try to take them as we go along. But I'm also multitasking here, so apologies if I don't get to it. The first thing is errors and omissions insurance. I hope everybody understands the importance of errors and omissions insurance. Errors and omissions insurance exists to protect you if you make a mistake, if you are negligent, if you book a trip for the wrong date. Your client shows up at the airport in July, it turns out they were a no-show for their flight in June. That's your mistake. Simple human error happens. And if it's expensive, errors and omissions insurance can be helpful to you. I have said this before, even if you are a hosted agent or a hosted advisor, and your host agent has an errors and omissions insurance policy, I have a strong view that that is not enough for you, and you should get your own errors and omissions policy in addition to that. But it's also not a substitute. Errors and omissions insurance is not a substitute for well-crafted terms and conditions. So what is a terms and conditions document? Terms and conditions document governs the conditions under which you are going to work for your clients. It should be the boilerplate for all of your trips. My recommendation is that you have one terms and conditions document that covers all of the trips that you book for people, whether they are groups, whether they are destination weddings, whether they are individual FIT trips, if it's a simple sun and fun vacation, air only bookings. Have a boilerplate terms and conditions document that covers you across the board. You're going to want it structured as a legal agreement, and you're going to want to make sure that your clients actually affirmatively sign on to that agreement, because it doesn't do you really any good. It doesn't really do you any good to have these really fantastic protections for your business if your clients aren't actually agreeing to it. And I want to just say a couple of words about using templates or cookie cutter forms. It is better to have something rather than nothing. But if you have purchased a template or a form or a document from somebody other than a lawyer, even if that agreement that template was drafted by a lawyer, if it hasn't been fine tuned to the specifics of your business, I would be concerned about that. And if you haven't had an attorney go over it and review it and walk you through it, that would be another concern that I would have. There are certainly some templates around there that are floating around that are comprehensive, but I would say, well, actually 100% of the time when people have purchased templates from somebody else and then bring them to me and ask me to review them, there are almost always things that are missing, and sometimes there's some very important things that are missing. So I am not an advocate of using something that's cookie cutter and out of the box, because it may not protect you from the things that are really important to you. What goes into a terms and conditions document? There are lots of things that go into a terms document, but I'm just focusing for now on the things that are going to be in your terms and conditions document, that are going to protect you in the case when something goes sideways where your clients are traveling and you're concerned that the client might try to come after you for those things. So the first provisions that I think are important are having some provisions that clarify your role as a travel agent versus travel advisor. There are also a lot of advisories that you're going to need to make to clients that you can do in your terms and conditions document. Disclaimers of liability or responsibility. This is really the meat and potatoes of any terms and conditions document, and it's a really important provision. Limitation on damages. This is something that I don't see in a lot of those cookie cutter templates that are out there. And a complete agreement clause. And we'll talk about each of these one-to-one. So the first is your role as a travel agent versus being a travel advisor. So as a travel agent, you have a fiduciary duty that you owe to suppliers. The agent part of travel agent is that you are a booking agent of the supplier, meaning you can't violate the supplier's pricing policies. You're not allowed to misrepresent the products. Those are duties that you owe to the suppliers. But you've all been aware, no doubt, that we are all putting ourselves out there as travel advisors to reflect the role that we have in giving advice to our clients and counseling them on the best types of trips for their style and their budget. And so you also owe duty of care to your clients as a travel advisor. And being in that middle place is a complicated place to be, because you have duties that flow in both directions. A lot of times for clients, particularly now when travel is resuming and travel is more complicated than it's ever been before, there are lots of people who are reaching out to travel advisors for the first time, and they don't necessarily understand what your role is. And so having a provision in your terms and conditions that says that your clients agree, that they understand that you are acting as the booking agent for the suppliers, and that distinction, whether they understand it intuitively or not, they can agree in your terms and conditions that they understand that. And if you've got them agreeing to that, even if it's not making sense to them intuitively, you've got a contractual agreement that says that they understand that. That can help you a lot, and we'll see why that is a little bit later. Advisories to clients. So because you have a duty of care to your clients, there are all sorts of stupid things that you have to tell your clients that you shouldn't have to tell your clients. But somewhere along the way, somebody showed up at the airport without a passport and said, my agent never told me that I had to have a passport to take an international trip. And they sued their travel agent, and now there's a court case out there saying that you have an affirmative obligation to tell your clients who are traveling internationally that they need a passport, or they need a visa, or they need a driver's license. So a lot of the things that you are legally required to disclose to clients as part of your duty of care, those are things that you can put in a terms and conditions document. And when you put that in your terms and conditions document, you are shifting the responsibility to your clients to take care of those things that they need to do. So even if you don't say the words to your client, hey, you got to have a passport, just FYI, and your clients look at you, of course I have to have a passport. I know that. Can't go to France without a passport. Well, you still have an obligation to say that. If you didn't say that, you can say it in your terms and conditions, and when your clients agree to it, you've got your bases covered. Okay, limitation of responsibility. This is again the meat and potatoes of the whole document. So, limitation of responsibility clause. This is where your clients are telling you, or rather, excuse me, you are telling your clients, and your clients are agreeing that you are not responsible for anything that your supplier does or fails to do that can cause damages, injury, loss, or anything like that. So, um, accidents, unsafe conditions, policies that your clients have that they feel have damaged them, and even bankruptcies and defaults. So, if you book your clients at a resort, there's seaweed on the beach, your client is upset because it smells horrible and it ruined their vacation, they blame you because you put them at that resort. So, obviously, it's not your job to clean up the seaweed on the beach. And so, in your terms and conditions, if they've agreed to the limitation of responsibility clause, they're agreeing that they cannot and will not hold you responsible for something like that. Or it could be something more serious. It could be that, the helicopter that's going to land on the glacier gets into a horrible accident, your client gets injured, comes back and files a giant lawsuit against everybody and anything. This language, obviously, you're not in charge of the maintenance on the helicopter. The helicopter pilot is not your employee. So anything that happens while your clients are traveling that is out of your control but in your supplier's control, this is the language where they can agree that you're off the hook for that sort of thing, including, as I said, policies. So if your supplier has a no refunds policy and your client wants to cancel at the last minute and they're upset about that, having a terms and conditions document that includes a clause like this can really protect you from having the client come after you saying, I don't like that policy, you booked me with that supplier that has this ridiculous cancellation policy, I want my money back, I'm suing you. Bankruptcies and defaults. Obviously, you're not going to want to book with a supplier that you know is about to go under, but it's also not within your control if the supplier decides to default on their debt payments and shut their doors and stop answering the phones. So, in the limitation of responsibility clause, you can agree with your clients that they don't have the ability to come after you for something like this. Okay, limitation on damages. This is a provision that I put in all of my terms and conditions documents. I don't see it in some of the templates that are out there, but your clients can agree in your terms and conditions that they understand that because you are a booking agent, you are paid based on commission and fees. And because you are paid on commission and fees, they can agree in your terms and conditions that that if they do figure out a way to drag you into a dispute or a lawsuit, they can agree in advance that you will not be liable for anything beyond the commission that you made on a trip and any fees that you charged. So if you made $700 in commission and you charged a $200 fee, and your client tries to sue you for $30 million, they have already agreed in your terms and conditions that $900 is the most that they can get out of you. And so that provision would be a good way to get you out of a lawsuit more quickly, because your attorney could call the other side's attorney and say, hey, look, buddy, I don't know if you realize that your client agreed to this, but you're suing my client for $30 million. They've already agreed that the maximum amount of damages is $900. So how about we cut you a check for $150 and you let us off of this? So that's an example of how that might work. Complete agreement clause. This is kind of boilerplate in documents, and it's not something that I always see in some of those templates that I was talking about. But a complete agreement clause is a clause that says that your terms and conditions document is the real deal. That it is those are the terms governing the relationship between you and the client, and that nothing that you say to your client in a phone call or an email undercuts or undermines those terms. And particularly if you're in an agency where you have sub-agents, you're definitely going to want something like this. So an example of, if your client asks you, hey, is Cancun a safe destination? And you say, absolutely, Cancun is as safe as any place in Europe. Well, if you've got a well-crafted terms and conditions document, there's going to be something in your terms and conditions document that's going to say, as part of the advisories that you're supposed to make to clients, that it's their responsibility to do their research to find out whether a destination has any risks attached to it. High crime, terror threats, civil unrest, coronavirus. That they can go to neutral government websites. They can go to the State Department website to see if there's an advisory. They can go to the CDC website to see if there's a COVID outbreak. And it's their responsibility to decide whether or not they're comfortable taking the trip in light of what they find when they go to those websites. That's what's in your terms and conditions document, but your subagent said, oh yeah, it's totally safe. Well, the thing that your subagent said doesn't matter, because the terms and conditions document is the real deal. That's the document that applies. And so having a complete agreement clause in your terms and conditions document is the thing that's going to help you on that. So those are the 5 things that I recommend that you put into a terms and conditions document for this issue of having a client potentially sue you for something that goes sideways when they're traveling. There are all sorts of other things that go into terms and conditions documents, like mandatory disclosures. Travel is a highly regulated industry rather, and you're going to need to have those mandatory disclosures in there. There's some other, lots and lots of different specific things related to advisories where you're shifting the responsibility of the client. But a good comprehensive document. I know people want short documents. There are ways to get your clients to agree to a longer document without rubbing their nose in a bunch of legalese. But I would not recommend that anybody cut a corner on having a good solid terms and conditions document. But even with a good solid terms and conditions document, there's always the possibility that somebody could come after you anyway. So you can be sued for a good reason, a bad reason, or no reason at all. And that's why how you handle those emergent situations is really important. So here's what I recommend in terms of responding to a crisis. And I have clients right now who are dealing with situations that happened while their clients were traveling. There is the potential for litigation, and they are wanting to keep themselves firmly in the territory of, I am the booking agent and I am not responsible for those things that happened on your trip, because those things that happened on your trip were out of my control. So first thing is, you want to be responsive. Don't freeze, don't lock down, don't button yourself up and ignore your clients, because if they're reaching out to you for help and there's radio silence, then that's just going to lead them to pivot and look at you for, why aren't you helping me? So you want to be responsive. But you also don't want to overstep your role as the booking agent. So in every communication, I recommend that you be very, very clear to your clients what your role is and what your role isn't. If your client wants a refund because of this horrible thing that happened to them, you should reinforce to them that you're not in charge of deciding whether or not that refund is issued, but absolutely be helpful and offer to be the conduit of information to your supplier partners, relay information back to them. I often get questions about insurance claims. I don't recommend that you file the claim on behalf of your client, but you should absolutely assist them in getting the information together about the documents and the booking confirmations and those things that you would need in order to help them make that claim with the insurance company. Do not become angry or defensive. If they smell blood in the water, that can be the thing that leads them to escalate it. But call your lawyer. But keep your lawyer in the background, because again, your first impulse might be, I'm going to have my lawyer send a letter explaining why I'm not responsible for any of this. That can also escalate things. So your lawyer can give you advice on how to respond to those things. But once a letter comes from a lawyer, that's a gun that can't be unfired. That's a bell that cannot be unrung. So keep the lawyer in the background until you get to a point where you actually need the lawyer to actually reach out and do something. Reach out to your insurance the moment you think you might have a claim, because in some insurance policies require the insurance company to lead the defense of the claim in order for you to have coverage. So if you get too far down the road and then you call your insurance too late, that could lead to you not being covered for anything that your insurance policy might otherwise take care of for you. And then, of course, document everything. So that is those are my recommendations. If you know that a dispute is on the horizon, really try to be put yourself in the best possible position to make those first moves. Call your insurance, call your attorney. Don't ignore your clients. Don't be defensive, and really try to make sure that you are being helpful without overstepping your role. So. Um, so just the key takeaways from this presentation: errors and omissions insurance is not a substitute for well-crafted terms and conditions. Make sure that your terms and conditions are airtight. How you respond to an emerging crisis can really help you keep the cost down so that it is not so that it's not expensive to make this thing go away. I've seen already in some of the, I anticipated this. There are some questions in the chat. If you'd like to talk to me about your terms and conditions document, there are a couple of things that a couple of ways you can reach out to us. There's a contact form on our website, which is www.carpentertaylor.com. My crushingly awesome practice manager, Colleen McHugh, is available at cmchugh at carpentertaylor.com, and she can arrange to set up a complimentary consult. Calling us by phone, you can leave a message, but it might be a while before we get back to you, and it's just not an efficient way to get in touch with us. Facebook Messenger, people reach out to me on Facebook Messenger all the time, and it is also not the best way to reach out to us. So an email or a message through our website is probably going to be the fastest way for us to get you onto my calendar. People have asked, how much does it cost to do a terms and conditions document? Our rates really vary on a variety of factors. I have discount arrangements in place with ASTA. I'm part of the ASTA attorney referral program. So if you're an ASTA member, my rates, including my flat rates for terms and conditions, are a little bit lower. There are some host agencies and other organizations where I have discount arrangements in place. And then there's some things that I don't do on a flat rate, I do on an hourly rate. But I am mindful of the fact that people need to people need to manage their expenses. And so I try to keep, especially for terms and conditions documents, because they're so important and I do so many of them, I try to keep the cost reasonable. And I think the people who've worked with me will tell you that it is not an arm and a leg to get a terms and conditions document that's going to work for you put in place if you're working with me. And in terms of paying my invoices, a lot of people just have questions about, how do I pay attorneys and how much is it going to cost me, and am I going to get a big invoice that surprises me? If I'm doing work on a flat rate, after I deliver a document or policy to you and we go over it, then I usually send the invoice at the end of the month after we've done that work. And for hourly work, if I was doing something like an independent contractor agreement or a complicated group contract for you, that sort of thing I would invoice at the end of the month after I've done that work. So if it's over a couple of months, you might get a couple of different bills, but I always give estimates of my time. So you're not going to get an invoice from me that surprises you. So again, making the attorney advertising disclosure, because if I'm talking about ways that you can retain me if you want to, that's just a little more information there. Again, because this is the most common question that I get whenever I do a webinar. The question keeps coming up: is this being recorded? and that aside from what time is it, is like, I mean, I think I've given that answer about 1 million times. So this will live on my Facebook page of my law firm Facebook page. This will also be on my YouTube channel. There are some other presentations that are available on my YouTube channel if you want to go and look at those. I'm going to try to. So the answer is yes. This will be this will be recorded. I'm just going to give you. I'm going to scroll back and look at some of the other questions that I was seeing as we were coming. I saw a lot of questions about. I saw a lot of questions about what are the mechanics of getting your clients to agree to a terms and conditions document, and I think that technology is your friend in this regard. So if you have a program like Travelify or Traveljoy or even if you're using or TESS or Vacation CRM, there are or Vacation Creation. There are lots of programs out there where you can build a form and use that form as a vehicle to get your clients to sign on to your terms and conditions. When I draft terms and conditions documents for people, I spend some time with them, counseling them on the workflow piece of it, because like I said, it doesn't do you a lot of good to have your really great protections in your terms and conditions document if your clients aren't actually signing on to it. And so when I draft a terms and conditions document on a flat rate, I also counsel people on the workflow piece of it. I suggest using a client agreement as a shorter, more user-friendly way to get your clients to sign on to that terms and conditions document. I give people a template of a client agreement if they want to do it this way, and then we kind of talk through all of that. I am not a tech person. I am not your tech person. I'm not going to set up your TravelJoy for you, but I use TravelJoy in my business, so that's why I keep saying TravelJoy. But I have a tutorial for how to build some of these forms, which I'm happy to share with people. I think it's already on my YouTube page if you want to look at that. But again, a terms and conditions document that's custom for your business, that really is fine-tuned to the types of trips you have and the clients that you use, and then making it easy for your clients to sign on to it by checking a box on a form rather than sending them 8 pages of legal stuff every time they want to book a trip with you. So that is part of it. Fee structures and credit card authorizations, chargebacks are a huge problem right now. That's part of the conversation that I generally have with people about the workflow. So that's all part of it as well. But you don't need wet ink on paper. An e-signature is fine. Checking a box on a form and returning it to you is fine. And then whether they go to the link on that website and read the terms is up to them, but when they check the box on the form and return it to you, that's enough to protect you. Let's see here. Is this recorded? Is this going to be recorded? Is this going to be recorded? Yes, it's going to be recorded. It will stay on the website. I'm just trying to see here. Somebody's asking about LLCs. What happens to us if we don't have an LLC? The form of your business is important. If you are a sole proprietor, there is the potential that if somebody does sue you, that your personal assets could be attached to liabilities of your business. And that's why most people form either a corporation or an LLC. The LLC form is pretty flexible. The great thing about an LLC is you can be taxed as an individual, but still have the protections of your personal assets protected from liability. My office can set up LLCs for people if you want us to do that. We're able to do that in all 50 states. We work with a service that can help us do that for you. I'm just trying to see other things that are here. Okay. Is it expensive to do an LLC? That is going to really depend on what state you're in. So in New York State, it is super, super expensive because you have a publication requirement, which most states don't have. So if you're forming an LLC in New York City or New York State even, but especially New York City, not only do you have to put the filing fee together, but you also have to publish a notice in the newspaper, and that's where I think it gets super expensive. But my practice manager, Colleen, who is also a crack paralegal, has been working with people on forming LLCs and also seller of travel registrations and those types of things where we can help with that. Some questions earlier about if you've got a group, do you need to have everybody in the group sign the terms and conditions in order to be protected? I put a provision in terms and conditions documents when I draft them that says that the lead traveler is taking responsibility for all of the bookings in their reservation, including bookings for other people where they're authorized to make those bookings. So hypothetically speaking, you've got a multi-gen family group and you're talking to grandma and grandpa, and suddenly you get a call from the daughter-in-law who says, what is all this? I never agreed to any of this. And she's upset. you can go back to your lead travelers and say, hey, just FYI, you agreed to my terms and conditions, you're on the hook for that. But the other thing that you can do is you can have people agree to the terms and conditions on as part of a booking information form. So if you need information to get people to book into that group, you're going to need names, addresses, maybe dates of birth. You can have people check a box on that info form that says, I'm agreeing to your terms and conditions. If people are making payments, I strongly recommend that you also have people agree to your terms and conditions whenever they make a payment, if they make a deposit, if they make a final payment, if they add supplemental services. I authorize you to charge my card ending in 4567 in the amount on this invoice, and I agree to your terms and conditions, which are located at wherever it is. And that is that's an additional way to get them to agree to your terms and conditions. Let me see here. Am I on? Yes, I am. I am actually on vacation right now. So I don't know if that was directed at me or somebody was talking to a friend. But can we use a T&C if we're a franchise owner? If you have a franchise and or if you are hosted and your host agency is requiring you to follow a process as a way of protecting their booking credentials, you should not violate the terms of your franchise agreement or your hosting agreement. Most host agencies, don't tightly control how their independent contractors run their businesses, because that runs the risk of putting them in employee territory. But you should definitely follow the instructions with your host agency agreement. So I'm just kind of looking at some of these. I want to go back to some of the earlier ones that I missed. What's the difference between a client agreement and a terms and conditions document? And do you need both? So a terms and conditions document, as I mentioned earlier, that should be the boilerplate for all of your trips that you book. You want that to be stable and consistent. You want it to be, you don't want to be making exceptions to that. So that's one of the reasons why I would recommend that you put your fees outside of your terms and conditions document. Put your fees in a client agreement, because that way you can have multiple client agreements for multiple clients. So you can have a client agreement that has no fee structure for your friends and family. You can have one for clients that are super difficult and you want to charge them an extra high fee. You could have one for groups. You could have one for school groups where you have an additional box to check that they agree to the student code of conduct. But the client agreement is where you can be flexible and adaptable. Your terms and conditions, you want that to be stable and consistent to cover you across the board. Let me see here. I'm seeing a couple of questions about credit card authorizations. I recommend that people get a credit card authorization for each and every charge. Like I said in the beginning of this, chargebacks are a huge problem right now. And if you have a supplier that comes after you, maybe they're coming after you, I don't know. If you have a supplier who comes to you and wants proof that you have authorization to use your client's card, you're going to need an authorization that shows the amount of the charge, when it was authorized, what it was for, and what card it was. So if you are taking credit card authorizations over the phone and somebody's like, oh, can you just put that through on my card that you've got on file? I get why people want to do that. It's convenient for the client, but you absolutely need a written authorization for each and every charge that you make. Otherwise, you're going to potentially have a client coming after you. If a client, just not a client coming after you, if you have a client that says, I don't want to, I know I'm within the final payment deadline, I don't care, I'm going to get that money back from my credit card. If you were the one who put the charge through with the supplier using your client's credit card, they're basically accusing you of credit card fraud. And so if you don't have an authorization to prove that you had authorization to run that charge, the supplier could well come after you for the amount of that charge. So if you don't want to pay for $10,000 of your client's vacation, you should be getting a credit card authorization each and every time. And I know it's not convenient, but again, tech tools can be your friend with that. TravelJoy can set up an invoice and automatic payment reminders. Some of the other things can do that too. So that's my thing on chargebacks. I also put something in terms and conditions documents that say that if your client where your client agrees that unless it's a case of fraud, they're not going to file a dispute with with their bank to do a chargeback. That can be helpful because that would give you the ability, if your client does the chargeback anyway, and you do get dinged for $10,000 of your client's trip, you could go back and, if you needed to, take this to a judge, explain, Your Honor, this was not a fraudulent charge. I was damaged to the tune of $10,000, plus I'm owed attorney's fees and court costs, et cetera, et cetera. And that would be a way to kind of recover that money. Obviously, nobody wants to sue a client, but if you've got a client that you've tried to get them to back off, you tried to get them to reverse the charges, they're being unreasonable, and it's a loss that you just can't absorb, then I would recommend that you have at least have that in there for peace of mind as a last resort in case you need something. Are you able to do terms and conditions if I'm located in Wisconsin? I have clients in almost every state that I represent on transactional matters. I cannot go into court for you in Wisconsin if you go into state court, but I don't do that kind of litigation anyway. So, but there are really only like seven or eight attorneys who know the travel industry and represent small businesses in the travel industry. We all know each other. We all talk to each other. They're all awesome. So if you want to reach out to them through the ASTA Attorney Referral Program, I know they will take very good care of you. But there aren't, in some states there just aren't attorneys who understand the industry who do this kind of work, and so on transactional matters, drafting documents and policies, I'm absolutely happy to help you. If you've got a dispute with somebody in another state, I'm absolutely able to help you. If you've got clients in other states, if you've got suppliers that you work with who are based in other states, those are situations where it's interstate commerce and it can easily be viewed as a federal matter, so that shouldn't be a problem. Let me see here. How often should you revise your terms and conditions? I put a provision in the terms and conditions document that says that you have the right to update your terms and conditions whenever you want, whenever you need to. But again, at the same time, I recommend that you have them be stable and consistent. And so even when COVID happened, I think there were maybe 2 or 3 small things that I changed in my boilerplate, but you want something that's going to really be workable for, we've just dealt with COVID. Before COVID, it was Zika. Before Zika, it was something else. And, I mean, having something that specifically says COVID is not going to help you as much as having something that says you're obligated to have vaccinations or health screenings, and it's your responsibility to find out what those are and take care of that. Of course, you're going to be helpful to your clients and try to tell them what those requirements are. But if you get it wrong, you've got the savings clause again, that it's a complete agreement, that nothing that you say to your clients undercuts what's in your terms. Your terms are going to say it's the client's responsibility to figure that out and do it. So if you give them bad information or the wrong information, they're not going to be able to come after you for something like that. So, how often in terms of how often should you have it updated? My recommendation would be that if you have a relationship with an attorney is going to have their eye on that for you. I keep my eye on that for clients, and I go through my client list to see, these are the businesses that have the language on whatever it is, and then I will have send around updates to those clients, and I don't send invoices with those updates, but it also doesn't happen very often. So, if my clients know that if something changes, there's a new regulation that passes or something like that, I'm going to reach out to them and let them know what they need to do to take care of it. And I think most other attorneys would also do that with their clients as well. Somebody saying that they have both an LLC and are also an S corporation. That's true. You can do that. It's fairly uncommon, but you can have a limited liability company that is taxed as an S corporation. I've got a couple of clients who have that. I'm not a tax attorney, so if you're thinking about what the best business form is, I mean, I can tell you my perspective from limiting liability, but in terms of the tax treatment, you're going to want to talk to your tax professional or tax accountant. Um, uh, let's see here. What else do we have? Oh, it's actually 9:45 in Hawaii. So I'm going to have to kind of end this soon. I'm just looking to see if there are one or two more things that I haven't covered. Okay, I think I've covered most of these things, but again, I'm going to just kind of put my contact information up as well. That's where you can find me if you need to. Again, if you want to reach out to me, I do complimentary consultations, and the best way to reach out to us is either by visiting our website at carpentertaylor.com. There's a form there, or you can send Colleen, my practice manager, an email, cmcq@carpentertaylor.com, and she can try to find a time to put you on my calendar. I will say that even in anticipation of this webinar, because of the thing that happened with the lawsuit in Texas over the firefighter who went to Mexico, that has generated a lot of requests for new consultations, and so my calendar is a little bit jammed up right now. If you have something that's time sensitive, I'll do my best to try to prioritize that. There are also attorneys who are participating in the ASTA attorney referral program who are available to help you as well if you want to reach out to them, if you're an ASTA member, and they will give you a discount. So thanks very much, everyone, and I'm very grateful for having so many supportive people here. Again, this will be recorded. It is being recorded, and it will appear on my Facebook page of my law practice and on my YouTube channel. And very happy to see so many friendly faces and names in the chat. And let me know if I can be helpful. Thanks very much, everyone. Bye-bye.